So, what I'd like to talk about briefly today is the question that seems to keep coming up in our practice, which is whether people have to go to work, if I can simplify it that much. We are at a stage in the COVID-19 pandemic where people are getting back to business, people are being recalled to work either from a layoff or from working from home. And in our practice at Render Law, in the webinars we're doing, in my role as 680 News' go to employment lawyer, the most common question we're getting breaks down to this: do I have to go back to the workplace when I'm recalled? And the simple answer is yes. And it's actually fascinating to most of us that so much has changed in such a brief time that we're even asking the question. In the past times, we all knew that if you went to work on Monday and Tuesday, you couldn't just choose not to go to work on Wednesday. I mean, you might do that and call in sick, but you needed to just have the option. You basically had to lie about it. Whereas now, people seem to think that they have this option to just decide that they don't want to go back to work when they're being directed to by their employer. They can just decide they're not ready yet. They prefer not to. And what's perhaps even more surprising is so many employers don't seem to think they can do anything about this. The bottom line is that attending at work wasn't a choice before, and it's not now. If you've been on a layoff, if you've been working from home, and you're directed to go back to the workplace, you have to. And if you don't, you're risking your job. And if you think that you're going to stay at home and continue to collect benefits like the CERB, you risk that also, because the CERB is there for people who cannot work or are unable to work, not people who choose not to. I think it's important to understand there are three exceptions to this rule that you have to go back to work. And very quickly stated, the first one is if you are entitled to a leave of absence, if you are unable, and I focus on the word unable, to work due to COVID-19. Second exception is if there is a true need for accommodation under human rights laws. And the third exception is you have the right to refuse unsafe work. But a general concern about going out in public, a general concern about being in the workplace, that's not going to trigger any of those entitlements, and nor will a preference. And one of the examples we've seen a few times lately is if someone chooses to stay home and look after their children, that's not a need if there are other viable options. There must be a specific, legitimate basis for saying that you are unable to work due to COVID-19 or that you need accommodation under human rights laws. So I'm encouraging everyone, please don't risk your job. If you're an employer, please don't compromise your business interests by assuming what the law says. We're working with many clients on both sides of the fence, so to speak, to help them understand their rights and obligations. I think I mentioned this last month. We prepared a 30-page guide to getting back to business, which I'm happy to share. So feel free to reach out and we'll get you a copy. But don't make any assumptions, because as we always say, most errors are made because people just don't take the time to understand their rights and their obligations in the employment relationship. That's all I have to say on that topic.